Yes, my lord. I appear with S. Shaba.
Okay, Samuel Shaba.
Yes, my lord. For the third defendant.
Okay. So this is my, okay. So this is my judgment with regards to Ahua Augustine's case, Ahua Augustine and others.
Score places.
The claimants commenced this action by way of complaint and other accompanying processes dated 4th December 2017 and filed on the 15th December 2017, asking for the following reliefs. Number one, a declaration that the non-payment and withholding of the claimant's salaries by the defendant without lawful justification is unlawful. Number two, an order for payment of the sum of 3,250,000 naira to the first claimant, being the first claimant's salaries unpaid by the defendant for a period of 26 months, recording from October 2016 to November 2017. Number three, an order for payment of the sum of 440,000 naira to the second claimant, being the second claimant's salaries unpaid by the defendants for a period of 16 months, recording from July 2016 to November 2017. Number D, an order for payment of the sum of 774,000 naira to the third claimant, being the third claimant's salaries unpaid by the defendants for a period of 18 months, recording from June 2016 to November 2017. Number E, an order for payment of the sum of 950,000 naira to the fourth claimant, being the fourth claimant's salaries unpaid by the defendants for a period of 19 months, recording from May 2016 to November 2017. Number F, an order for payment of the sum of 412,500 naira to the fifth claimant, being the fifth claimant's salaries unpaid by the defendant for a period of 14 months, recording from September 2016 to November 2017. Number G, an order binding the defendant to compute and pay the claimant's salaries as same shall fall due from December 2017 till the date of judgment in this suit. Number H, an order directing the defendants to resume payment of the claimant's salaries. Number I, an order directing the defendant to pay to the claimants a sum of 10,000 naira general damages to assuage the emotional, financial, and all sorts of discomforts and losses occasioned the claimants as a result of his holding of the claimant's salaries by defendants. Upon service of ordination process on the defendant, the first and second defendant entered appearance and filed a joint statement of defense and a notice of counter claim via an application which was granted on 7th of March 2018. The first and second defendants' notice of counter claim asked for the following reliefs. Number one, the first and second defendants repeat the amendment in the statement of defense, that is paragraph 1 to 10, for the purpose of the first and second defendants' counter claim. Number two, whereof the first and second defendant counter claim against the defendant, against the plaintiffs, the cost of this frivolous and vexatious suit to the tune of 10 million naira only. Similarly, a third defendant filed a memorandum of conditional appearance of defense and other defense processes on 29th of January 2018 via leave of court granted on 7th March 2018. claimants file a reply to the counter-claim assessment or defense of the defendant as the case may be. Case of the claimants. Claimants from the pleading stated that they were variously employed by defendants between August 2013, November 2015, and January 2016. And they worked until November 2017 when the defendants would held their respective salaries. It was averred by the claimant that the third defendant, through one of his developmental policies, established entrepreneurship development centers, EDCS, in all the 6 geopolitical zones of the country for the purpose of undertaking entrepreneurship development and training. Claimants avowed that in establishing the Entrepreneurship Development Center, the third defendant executed a tripartite agreement with the government of Benue State and the first defendant. That by virtue of the tripartite agreement, the third defendant is the financier of the center, while the first defendant is the implementing agency, and the second defendant is the alter ego of the first defendant. As the alter ego of the first defendant was responsible for taking decisions regarding the administration and management of the first defendant. The case of the claimants is basically for payment of the salaries. Case of the defendants. The first and second defendants deny the claim of the claimants, and Nevada is not all the staff of the Entrepreneurship Development Center that were the staff of the first defendant. The first claimant resigned his appointment with the first defendant, while the second to fifth claimant were never employed by them, but worked with the former program director, Professor Teo. And upon termination of his appointment, the services ceased to exist from August 2016. Third defendant also vehemently denies liability over the claims of the claimants and stated that the tripartite agreement the claimants are relying on was executed between the third defendant and the Benue State government and not the claimants. Trial commenced on the 1st of April 2019, and 4 witnesses testified on behalf of the claimants. The first claimant, Ahua Augustine, testified at CW2 by adopting his 2 depositions dated 18/12/2017 and 17th April 2018, and tendered exhibit AAU 1 to AAU 7. Third defendant, Teso Gabriel Ako, testified at CW2 by adopting his deposition dated 18th December 2017 and tendered exhibit AAU 8. Offer of appointment of claimant number 3 effective from 15th December 2015. Fourth claimant, Ainge, gave evidence at CW3. He adopted his sworn statement on oath dated 18th December 2017 and tendered exhibit AAU 9. Second claimant testified as CW4 by adopting his sworn statement on oath dated 18th 12/2017 and tendered exhibit 10. Claimants' witnesses were cross-examined by counsel to the respective defendants, and the case of the claimants was closed as there was no re-examination. On the 5th of November 2019, one Daniel Inyang testified on behalf of the third defendant as DW1. He adopted his sworn statement on oath dated 29th January 2018 and identified exhibit AAU 2. DW1 was thereafter cross-examined by the respective counsel for the claimant on the first and second defendant, and subsequently discharged in the absence of any re-examination. The matter was then adjourned for adoption of final written addresses, as the first and second defendants decided not to call any witness. Submission of the third defendant. Final written address of the third defendant dated 6th of February 2020 was filed on the 7th of February 2020, wherein 3 issues for determination were formulated by counsel to it. Number 1, whether or not from the aggregate of facts pleaded and the evidence put forward before the court, particularly exhibits AAU 1, 2, 8, 9, and 10, claimant's case disclosed the course of action against the third defendant. Number 2, whether from the circumstances of this case there exists privity of contract between the claimants and the third defendant. Number 3, whether or not the claimants have proved their case to be entitled to the relief sought in this suit. Counsel submitted on issue 1 that this case revolves around the interpretation of Exhibit AAU to tripartite agreement. That all the appointments of the claimants made by the former program director were done contrary to clause 6.5 of Exhibit 2. And the burden lies upon the claimant to prove their claims for special damages with cogent and credible evidence. In defining what constitutes cause of action, counsel rely on the definition of the Black's Law Dictionary 4th Pocket Edition and cited the following cases. Counsel submitted that from the pleadings of the claimant and the documents stand that there's nothing to show any wrong committed by the third defendant against the claimant, except the allegation that the third defendant established North Central EDC. This in itself does not constitute any wrong done against the claimant. It is a submission of counsel that Exhibit AAU2 would give birth to the EDC, regulate its activities in all ramifications, and assign responsibilities to all parties, and it's not the responsibility of the third defendant to hire and fire or pay salaries of the claimants. Under clauses 6.5, 2.5, and 2.6 of Exhibit AAU2, third defendant gave a disclaimer barring anyone from using its name or logo for whatever purpose, except with written consent that the power to recruit, remunerate, and terminate employment lies the implementing agency. Counsel argued further that the perusal of Exhibit AAU1, AAU8, and AAU9 and 10 purported appointment letters clearly shows that the appointment of the claimant was done by the program director, even though it is on the letterhead of the first defendant. It was submitted that this fact was admitted by the claimants during cross-examination. Another counsel admitted that from the assessment of fact of the claimant, they are disclosing no reasonable cause of action against the third defendant, hence the action be dismissed. Counsel cited the case of Cookie and Fombo, Irene Thomas, and Ostraverin Olosho Shoei, and the case of Antata and Mohammed. On issue number 2, Learned Counsel submitted that it is only parties to a contract who have rights or liabilities under it as captured in the doctrine of privity of contract. That where parties to a contract agree that one of them will provide benefit to a third party is not entitled to sue to enforce the agreement. Counsel rely on the case of ADF and AIC Limited, Makwe and Umoka. According to counsel, there was no privity of contract between the third defendant and the claimant, and that the first and second defendant are not agents of the third defendant as Exhibit AAU vests each party with its distinctive roles. Counsel urged the court to hold that the instant suit is mollified, vexatious, and gold digging. And the counsel submitted on issue number 3 that apart from relief number 1, which is declaratory, reliefs 2, 3 are monetary, hence special heads of claim which are different from general damages. Counsel cited the case of Gani Badmos and Abegunde, Araba and Elega, Soma and FHA. In drawing a distinction between special and general damages, counsel contended that the claimants have not pleaded or shown credible evidence on how they incurred 10 million naira damage as a result of withholding their salaries. Counsel cited the case of Ede Saka and Osakwi. The submission of counsel that the claims for salaries and costs of prosecuting this suit, which constitutes special damages, have not been specifically pleaded and strictly proved with credible evidence by the claimants. That the claimants have failed to plead their respective payment vouchers from their employer or statement of accounts when the claimants have admitted through their witnesses that they were being paid through the bank. Counsel refer the court to the case of Ede and Governor Abia State, relying on the case of Mike Foy and UAC, Council submitted that it settled that you cannot put something on nothing and expect it to stay. It will collapse. Council in its final submission stated that where evidence adduced by a claimant in proof of special damages claim is deficient or unsatisfactory and is rejected by a court, his claim comes to an end. Council started the case of Idigbe and PHCN and argued that and urged the court to dismiss this suit against the third defendant with cost. Submission of the claimant. The claimant's final written address is dated and filed on the 23rd of March 2020 and was deemed as properly filed and served. It's dated on 3rd March 2020 and was deemed as properly filed and served by an order of court on 29th of September 2021. Two issues for determination were formulated by counsel as follows. Number one, whether or not any of the defendants have proffered a defense to the claims of the claimants in this suit and the effect thereof. Number two, whether or not the claimants are entitled to all or any of the reliefs sought by them in this suit. On issue one, learned counsel for the claimants submitted that none of the defendants has proffered a defense to the claimants to the claims of the claimants. That the first and second defendants who filed pleadings never called any witness to lead evidence in support of any of the averment in their pleadings. And why a party fails to support pleadings with evidence, there is therefore no evidence in support of the fact pleaded by that party. In support of this, counsel cited the authorities of owners of MV Gongola Hope and Small Feed Cases Limited, Benin International Limited and NDIC, Dingyade and Wamako. And the counsel submitted also that the statement of one Daniel Iang, who testified on behalf of the third defendant, is invalid and cannot be utilized by this court because the statement does not contain the mandatory clause as prescribed by Section 13 of the Oath Act 2004. That about the decisions in GTB, PLC, and Abiodun, and owners of MV Gongola Hope and Small Feed Cases Limited, Supra. Such a statement on oath and affidavit without complying with Section 13 of the Oath Act robs the statement and affidavit of its validity. Counsel further submitted that the decision in GTB, PLC, and Abiodun Supra, which is from the Court of Appeal, must be followed by this court. Counsel on this rely on the case of Suleiman, Commissioner of Police, Plateau State. Counsel further argued that the statement of defense of the third defendant is also invalid as it's not shown who among the listed counsel signed it. According to counsel, although there are names of 4 counsel listed on the face of the defense with a signature, there are no indication or mark showing who actually owns the signature. This, according to counsel, renders the statement of defense incompetent. Counsel rely on the case of SLB, Consortium Limited, and NNPC, and OK, Asia, and Oguini. Also, the argument of counsel that the NBA stamp and seal affixed the statement of defense must be connected to one of the listed names. That is, a stamp of a legal practitioner affixed to a document must be linked to one of the named counsel. Counsel stated the case of Yagi and Bagudu and urged the court to hold that the defense of the third defendant, like that of the first and second defendants, is invalid and liable to be struck out. The effect is that the claims of the claimant were undefendant, thus the facts contained in the complaint are deemed admitted according to Section 123 of the Evidence Act 2011 and the case of Dingeti and Wamako. On issue 2, counsel cited the Section 131 of the Evidence Act and the case of Okuble and Oyagnola and submitted that he who asserts must prove. Also cited Section 133, sub 1 and 2 of the Evidence Act and the case of Union Bank and Ravi Abdul Council adopted his submission under issue 1 that the defendants have no evidence against the evidence of the claimants. According to counsel, the first and second defendant who filed a defense failed to call evidence improve the facts pleaded, while the third defendant only made general denials to the claims of the claimants. The law is that mere general denials are insufficient. Counsel started the case of UBN and Chiamezi. Penal counsel argued that the position of the third defendant is that it's not responsible for the employment of payment of salaries of the claimants. Meanwhile, clause 5.1 of exhibit AAU2 shows that the third defendant was responsible for the funding of the CBN, NCZ, and EDC in Makodi for 5 years. Counsel argued that the claimants are entitled to all the reliefs. In response to the final written address of the third defendant, counsel argued that the issue before the court is who is responsible for the payment of the salaries of the claimants. According to counsel, the answer lies in clause 5.0 to 5.4 of exhibit AAU2, which made the third defendant responsible for funding of the program. Therefore, the claimants have shown cause of action in the third defendant and also proven the reliefs. Furthermore, counsel argued that the first defendant was responsible for recruitment of the claimant does not absolve the third defendant payment of salaries. Counsel urged the court to disregard the submission of the counsel as regards the preview of contract in exhibit AAU 2. The case of the claimant has remained unchallenged as provided under section 125 and 126 of the Evidence Act. Counsel submitted that civil suit at the timing and balance of probabilities or preponderance of evidence and cited the case of Suji and Ekocha. Sections 121 and 134 of the Evidence Act. Counsel submitted finally that the claimants have proved their case to be entitled to the reliefs sought. First and second defendants reply on points of law. On the 11th of May 2020, the first and second defendants filed a reply on points of law to the claimant's written address, even though they did not feel any opportunity to support their case. The first and second defendants adopted the two issues raised by the claimant and submitted that where a defendant raised his case on that of the claimant, the implication is that the claimant has not made a prima facie case for the defendants to answer. Also rely on the case of Aerobel Nigeria Limited and Fidelity Bank. Another counsel submitted that to succeed in their claim, the claimants must show that they were employed by a specific person who had the right to employ them and that their salaries were unjustly stopped. Counsel stated the case of Ano, Foreshi, and Wema Bank. Counsel contended that the claimants failed to show that they were employed by the first and second defendant, to show the terms of condition of their employment, and to prove the manner their salaries were unjustly stopped. Counsel argued also that the claimants failed to furnish this court with necessary material to show that the defendants connived and withheld account their salaries. No paid leave or statement of account has been tendered to know who was paying the claimant and how much were their salaries. Our counsel goes further to submit that the sections of the claimant's case depends entirely on the strength of his case and not on the weakness of the defense. Counsel cited the case of Michael and Ramotu Pedro. Also, the argument of counsel that once a litigant is ably represented by a counsel, he must not be physically present in court to prove his case. Counsel rely on the case of Mr. Samuel and Mr. Raymond Christopher. Counsel finally urged the court to hold that the claimants have failed to prove their case and are not entitled to any of their reliefs claimed. Both defendants reply on points of law. The third defendant's reply on points of law to the claimant's final written address was filed on the 18th of November 2020. In the third defendant's reply, it was submitted that the argument by the claimants on non-compliance with the provisions of Section 13 of the Oath Act 2004 is no longer tenable in view of the recent decision of the Court of Appeal in AG Akwa Ibom State and Akahiade. Counsel to the third defendant respond to the issue of the third defendant's counsel signing the statement of defense and not taking his name, submitted that the case of Williams and Adol Stam International Limited and Minor and EFCC have remedied that situation as long as the identity of the person to practice as legal practitioner is not in issue. Counsel submitted further that the third defendant never engaged the claimants and was never responsible for the payment of their salary. Each of the claimants specifically plead and prove with credible, real, and documentary evidence what were their monthly salaries. Counsel rely on the case of Ede and Governor Abia State, Supra. Counsel finally urged the court to submit the claims of the claimant with cost. Opinion of the court. I've carefully studied the submissions of the respective counsel and I've gone through the pleadings, the evidence adduced and exhibit tendered. To me, the issue whether the claimants have established their case by evidence to be entitled to judgment of the court would be apt. Claimant's case basically stems from the fact that the respective salaries from April 2015 and September 2015 to November 2017 were withheld by the defendant and thus seek to compel the defendant to pay what is due to them between the stated month they rendered services to the defendant. As it has been noted earlier in this judgment, the first and second defendants though filed a statement of defense but did not call evidence to support their pleadings. The contender that they not need to give evidence since they are represented by counsel. But I am unable to agree with the contention of the first and second defendants that not need to call any witness when they are represented by a counsel. The fact that the party is presented by a counsel does not obviate the need to call evidence. I must underscore the point that requirements and pleadings are fact as perceived by the party relying on them. And there must be oral or documentary evidence to show that the facts pleaded are true. Consequently, pleadings without evidence to support them are worthless and will certainly be deemed abandoned. This is the case of Cameroon Airlines and Otutuzi. Therefore, the amendments made in the first and second defendants' pleadings have not been supported by evidence, go to no issue, and are accordingly abandoned. As a consequence, the counterclaim is also dismissed. Although I appreciate the fact that the first and second defendant have fully applied to the court to call their witness via video conference. However, that application was refused because as of that time, there was no provision in our rules of court or practice direction that allows virtual hearing. Let me also address a somewhat few preliminary issues raised by the claimants. Another counsel for the claimant contended in their submission that the statement on oath of third defendant's witness is invalid because the statement does not contain the mandatory clause as prescribed by Section 13 of the Oath Act 2004, and that the decision in GTB, PLC, and Abiodun on that issue must be followed by this court. It was further argued that the statement on the defense of the third defendant is also invalid. There is no indication or mark showing who actually among the listed counsels signed the document. I must say that the law does not require a deponent to use the exact words in the Oath Act. I believe anything in substantial compliance with the requirements of that act will be enough in this area of substantial justice at the expense of technicalities. In the case of Etienne and Inyong and Ojibara and Governor of Para State, my view that an affidavit which is said not to comply with the provisions of Section 13 of the Oath Act is merely defective in form, not in substance. And any omission to include the words stated in that section will not, in the absence of any fundamental defect as to substance, render the affidavit invalid. Since the omission of the word will only affect the form in which the affidavit is presented, it was held in Commissioner of Land and Osuji that the form stated for concluding an oath in Section 13 of the Oath Act is merely directory. It's neither compulsory or mandatory. The era of undue reliance on technicalities is long gone. In regards to the case of GTBPS and Building Supra, cited by Land Council for the claimant, it must be borne in mind always that each case must be considered on its own particular or peculiar facts or circumstances. No one case is identical with the other or another. They may be similar but never identical. So it is with the instance. It is certain that a decision is only an authority for what it decides and nothing more. On the issue of whose signature on the third defendant's statement of defense, I have looked at the process. There are 4 names, and the name of the SM Onekutu is the first in the list. On top of it, there is a signature. There is also a seal of Simon Musa Onekutu on the process. To contend that the name of the counsel who signed the process must be ticked is, in my view, too trivial and misconceived. The case of Williams and Adult Stamp International Limited and Minor and EFCC, cited by the Land Council for the defendant, for the third defendant, are much relevant and on point. For the substantive matter, the claimants improved on the respective claims that they are all salaries by defendant render a total of 10 exhibits and call 4 witnesses. Exhibit AAU1 dated August 5th, 2013 is the offer of provisional appointment of the first claimant by the first defendant and signed by the program director. Exhibit AAU 8, 9, and 10 are dated letters of offer of provisional appointments of the second, third, and fourth claimant, signed by the program director of the first defendant. Aside from Exhibit AAU1, which shows acceptance of offer of appointment by the first claimant, there's nothing to show acceptance of the offer of appointment by the other claimants. The relevant contents of the claimant's offer of provisional appointment is as follows. Offer of provisional appointment. I quote, following your success in the recent recruitment interview conducted at the center, I'm pleased to convey the approval of both the Central Bank of Nigeria Entrepreneurship Development Center and its implementing agency, the African Community Bridge Foundation, offer you provisional appointment as upon your assumption of duties. The establishment unit will determine the appropriate remuneration on this position in line with our conditions of service and place you accordingly. Unquote. No defendant had on the part denied claimant at any point and rely on Exhibit 2, which is a tripartite agreement between the first and third defendant and the government of Benue State to show that claimants were not part of the agreement and the third defendant was not mandated to employ any staff on behalf of any of the parties to the agreement. From the evidence presented by the parties to this suit, it's shown that the claimants were at a point in time engaged by the program director of the first defendant, even though the craft of this case is for payment of salaries for services already rendered by the claimants. Paragraphs 14, 15, 18, 19, 20, 21, 22, and 28 of the complaint contains sums of monies computed by the claimant as salaries due to each of them up to November 2017. These paragraphs of the pleadings form reliefs B and F of paragraph 28 of the complaint. But it appears that there is less evidence before the court to corroborate these figures so claimed. None of the letters of appointment that is exhibits AU 1, 8, 9, and 10 has shown what any of the claimants is entitled to as salary. The letters only state that the establishment unit will determine the appropriate remuneration of the claimants in line with the employee's conditions of service. I've not seen any evidence that states how much is the remuneration of the claimants. I've not also seen and come across the conditions of service mentioned in the appointment letter of the claimants. GW2 said under cross-examination by the third defendant thus, and I quote, "If my salary is for 3,000 per month, salary is not written on exhibit AAU 8, but I was paid that amount as my salary by CBN EDC. I don't have evidence of payment of my salary, but I was paid through the bank." Unquote. GW3 also said under cross-examination by the third defendant as follows: "My appointment was not terminated and my monthly salary was 50,000 naira. I was being paid through EcoBank. I'm not with my pay slip and statement of account." There was also evidence of CW4 under cross-examination by the third defendant thus, and I quote, "My salary was 7,500 naira per month. I was being paid through the bank, but I don't have the bank statement." Unquote. It is evident in the instance case that there's no bank statement or account or pay slip or schedule of payment showing any figure as salary to the claimant or when it was actually last paid. The law that he who alleges must prove is still in place. In the instance case, the body lies on the claimants to prove that they're entitled to their salaries. The claim for salary being monetary sum is a claim for special damages. The tax therefore lies on the claimant to prove his specific claims. By the provisions of section 131 sub 1 of the Evidence Act, it is the duty of the claimants who assert the existence of a legal right that must prove that those facts exist. In the case of VP Industry Limited and Coca Industry Limited, the court held that the burden of proof lies in all cases, the burden of proof in all cases rests on the person who asserts. The claimant is required by law to plead and support what he has pleaded by credible and convincing evidence. And that evidence should preponderate in civil matters before his claims can be acceded to by the court. And where he fails to discharge the honors, his claim must fail. See the case of Hamza and Kuri. To prove an entitlement as in the instance case, claimants must refer the court to the exact provisions of the law, instrument or document that confer the entitlement. Here, the evidence of the claimants under cross-examination that they don't have pay slip or bank statement of account is apt. To the case of Mr. Mohammed Dungus and ENL Consortium. The law is that evidence ought to be laid before an award for special damages is granted. And to succeed in a claim for special damages, it must be claimed specifically and proved strictly. The fact that it appears to be admitted does not relieve the party claiming it of the requirement of proof with compelling evidence. See the case of NNPC and Clipco Nigeria Limited. The burden is therefore that of the claimants to prove to the satisfaction of the court the assertions contained in the pleadings, as failure of the defense to prove their defense or testify cannot absolve the claimant of this primary duty. See the case of Eye, Neyin, and Akinkobe. Fact that the first and second defendants adduce no evidence in support of their pleadings, which a law is deemed abandoned, notwithstanding. See the case of Ogunjemila and Ajibade. claimants still have the evidential burden to establish their claims for special damage with precision and not rely on the weakness of the defense. In the case of Ekedare and Adebara, a party may only rely on the weakness of the defense to prove his case, while the case of the defendant supports his claims. See the case of Shutu and Fashawe. The third defendant has referred to Exhibit AAU to submit that by the doctrine of privy to contract, the claimants are not privy to the tripartite agreement entered among the parties therein. Let me quickly refer to the relevant provisions of Exhibit AAU 2, plus 2.2 states. The bank shall finance the EDC in partnership with the state government, while the implementing agency shall manage the EDC in accordance with the provisions of this agreement. Implementing agency staff for the purpose of the implementation of the EDC shall not be regarded as staff of the bank and shall not hold themselves out as source to members of the public. The implementing agency shall be responsible for the day-to-day operations of the EDC and shall carry out its work in accordance with the provisions of this agreement and the operational manual provided pursuant to clause 2.7 of this agreement. Clause 5, the bank shall inter alia, number 1, provide funding for the EDC project for a period of 5 years, and as such, funds shall be applied to the following: cost of operation, cost of consultancy, personnel, trainer, and instructional materials. Implementing agency shall inter alia oversee recruitment, remuneration, progression, and exit of staff of the EDC. It's also provided in Appendix A of the agreement that the third defendant, as part of his contribution toward the operation of the EDC, will contribute salary and allowances of implementing agency staff on the EDC project. And I quote, from the community region of the entire provisions of Exhibit AU2, and in particular the provisions stated above, it can be observed that Exhibit AU2 is a tripartite agreement among the first, third defendant and the Benin state government. It is aimed at developing entrepreneurial skills for the purpose of reducing unemployment among citizenry. By virtue of the agreement, the third defendant shall finance the establishment of the EDC, and the fifth defendant shall be responsible for its management, while the Benin state government shall provide counterpart funding for training facilities to support the smooth and effective operation of the program. The project was for a period of 5 years. GW1 said under condemnation by the claimant that, and I quote, "Yes, the third defendant was funding the center by making quarterly payments. The quarterly funding of the EDC was based on performance, and the third defendant funded the project to its end." It can be observed that although Exhibit AU2 depicted the third defendant as the financier of the project, which shall, among others, cover personnel costs, but does not appear to be a clear nexus between the third defendant and the staff of the first defendant. And by the doctrine of privy to of contract, which is about the sanctity of contract between the parties to it, it cannot be said that Exhibit AU2 extends to the claimants who are outside the agreement. As a general rule, a contract cannot confer or impose obligations arising under it on any person except the parties to it. In other words, only parties to a contract can sue or be sued on the contract. And a stranger to a contract cannot sue or be sued on the contract. See the case of UBA and Jagaba. Arising from the above, and having not found any basis for the grant of reliefs B to F of the claimants, reliefs A, G, H, and I equally failed. Consequent upon the above, I am of the opinion that the claimants have not proved their case as required by law, to warrant the grant of any of the reliefs sought. Accordingly, the entire suit filed by the claimants failed and is hereby dismissed.
As the court pleases.
Yes, thanks.
My Lord, we appreciate the well-researched decision of the Honorable Court. We are grateful, sir.
Thank you, Mr. Anaze.
Yes, my Lord.
Thank you.
My Lord, we are grateful for the well.
Thank you, Ede. That's the abbreviation. Ede. Mr. Onekutu.
You should unmute himself.
You are muted. You are muted.
So, yes, my Lord, I was trying to appreciate my Lord for the well-researched judgment just delivered.
Thank you.
We appreciate my Lord for it.
Thank you. So it will be same appearance for the other case?
Yes, my Lord.
Okay. So this is the case of Professor Frederick case. So this is my judgment. A complaint dated and filed on the 3rd of October 2016, claimant in his statement of fact claims against the defendant the following reliefs. Number one, a declaration that purported termination of appointment of the claimant by the first and second defendants is null and void ab initio, same having been in naked breach of the term of the tripartite agreement. Number two, another of this honorable court directing the defendant to pay the claimant a salary of 616,000 naira only from April 2016 to the date of the judgment. Number three, an order of this honorable court directing the defendant to pay the claimant the sum of 50 million naira only in damages he incurred as a result of the wrongful termination of his appointment and non-payment of his salary thereof. Number four, an order of this honorable court directing the defendants to pay to the claimant the sum of 5 million naira by only representing the cost of this action. On service of the administration process, the first and second defendants entered appearance on 2nd February 2017 and filed a joint statement of defense on 31st January 2017. The first and second defendant also counterclaim against the claimant and seek for the following reliefs. Number one, the immediate return of the first defendant's iPad with the intellectual properties contained therein. Number two, the sum of 20 million naira for the deprivation of the said iPad and its contents. Number three, the sum of 5 million naira as cost of the suit for obtaining court order to open up the first defendant's office locked up by the claimant. Number 4, the cost of 5 million naira being the cost of replacing the damaged door, paying the carpenter and the enforcement team. Number 5, sum of 50 million naira for damaging the claimant's reputation before the third defendant. Number 6, the sum of 15 million naira for the missing of operational vehicle. Number 7, the sum of 50 million naira for stalling the operation of the defendant because of lack of operational vehicle. Number 8, the sum of 5 million naira representing the cost of defending this suit. Third defendant equally entered a conditional appearance and filed assessment of defense and other accompanying processes on the 1st of December 2016. Third defendant also filed a notice of preliminary objection on the 1st December 2016, which was overruled on 19 December 2017. Another notice of preliminary objection dated 9 September 2018 and filed on 13 September 2019, but the third defendant was also struck out. Case of the claimant. The relevant facts of the claimant's case as disclosed in his pleadings are that in 2013, he was appointed the program director of the North Central Entrepreneurship Development Program, and based on the tripartite agreement between North Central states and the first and third defendants, he was a staff of the EDC and not the first defendant. Claimant stated that he worked assiduously until 2016 when he was attacked by armed robbers who made away his official vehicle and other valuables. Claimant stated that he made a report at the police B division, Makodi, and 2 of the suspects were arrested. However, while the trial of the accused person was ongoing, second defendant issued him a query over the loss of the vehicle, even though he had notified the first defendant through the second defendant. And in May 2016, first defendant terminated his appointment, which led to this suit. The first and second defendant denied the reliefs as claimed by the claimant and stated that while the third defendant is the initiator and financier of EDC, it is the first defendant as the implementing agency that hires and fires. First and second defendant further stated that the appointment of the claimant was terminated based on the first defendant rules when he was found wanting in the disappearance of the operational vehicle attached to him. That the claimant was in constant violation of the provisions of the tripartite agreement. The second defendant equally denied the claims as put up by the claimant and stated that the second defendant is only an initiator and not the sole financier. It was the first defendant who had the responsibility to recruit and determine employment of staff according to the tripartite agreement. The defendant similarly advised that it never employed, recruited, or appointed the claimant as a staff of the ECD, and it was not involved in his termination. Defendants urged the court to dismiss the suit of the claimant as being frivolous, baseless, and vexatious. Trial commenced de novo before this quorum on the 1st October 2019. Claimant testified as CW1 by adopting his own statement dated 3rd of November 2016 and tendered a total of 6 exhibits as follows. FTT 01 to FTT 06. Claimant was thereafter cross-examined by counsel to respective defendants, and in the absence of re-examination, the case of the claimant was closed. Third defendant opened her defense on 5th November 2019, and one judge, Onwa Hanoi, testified as DW1 by adopting his own statement dated 3rd February 2017 and identified exhibit FTT 01 tendered by the claimant. Idigbe was cross-examined by counsel for the claimant and the first and second defendant and discharged in the absence of re-examination. And on the third day of January 2020, the first and second defendant elected to raise their case on the case of the claimant and the case of the defendant was closed and the matter was adjourned for adoption of final written addresses. Final written address of the third defendant dated 6 February 2020 and filed on 7 February 2020. Counsel on behalf of the third defendant raised 3 issues for determination as follows. On issue 1, according to counsel, issue 1 revolves around the interpretation of the relevant clauses in exhibits FTT1. In defining what constitutes cause of action, counsel rely on the definition in the Black's Law Dictionary and cited the following cases. Counsel submitted that from the pleadings of the claimant and documents tendered, there's nothing to show any wrong committed by the third defendant against the claimant. And the only amendment in the pleadings of the claimant referring to the third defendant are as contained in paragraphs 4, 19, 23, and 26 of the statement of fact, and there is no wrong in these paragraphs. Again, the claimant accepts the allegation that the third defendant turned a blind eye to the activities of the first and second defendant during his travels. Submission of counsel that exhibit FTT1 would give birth to the EDC, regulate its existence, and assign different responsibilities to all parties involved in the realization of the objectives of the EDC. It's not the responsibility of the third defendant to recruit, employ, and terminate the staff of the EDC. And the power to hire and fire lies with the first and second defendant as provided under clause 6.5 of exhibit FTT1. It's contained that under clauses 2.5 and 2.6 of exhibit FTT1, the third defendant gave a disclaimer barring anyone from using his name or logo for whatever purpose except with written consent. Counsel argued further that the result of exhibit FTT3 and 4 clearly showed that the appointment and termination of the claimant were done by the first and second defendant. And this fact was admitted under cross-examination by the claimant. And a counsel submitted from the above that the claimant's claim disclosing no reasonable cause of action against the third defendant, hence the action be dismissed. Counsel cited the cases of Kuku and Fompo, Irene and Most Reverend Olososoye, Entatan Mohammed. On issue 2, counsel submitted that it's only parties to a contract who have rights and liabilities under it as captured in the doctrine of privity of contract. That where 2 parties to a contract agree that one of them will provide benefit to a third party, the third party is not entitled to sue to enforce the agreement. Counsel rely on the case of AG Federation and AIC, Makwe and Ongoko, Technip and AIC, Mbata and Amenze. According to counsel, the third defendant was not privy to the contract of employment between the claimant and the first and second defendant, hence cannot be sued or be sued on account of exhibit FTT3. On issue 3, the other counsel submitted that apart from relief number 1, which is declaratory reliefs 2, 3, and 4 are mandatory, hence special heads of claim. Counsel started the case of Ganiyu Badmos and Abegunde, Osuja and Isuacha, Araba and Elege, Soma and FHA, in drawing a distinction between special damage and general damage. Counsel contended that the claimant has not pleaded or shown credible evidence on how he incurred 50 million naira damage as a result of the termination of his appointment. Furthermore, counsel argues that in a claim for wrongful termination, what plaintiff is entitled to as damages is what he would have earned at the appointment being determined according to the contract. Counsel started the case of Obanye and UBN. Your submission of counsel that the claims for salaries and costs of prosecuting this suit, which constitute special claims, have not been specifically pleaded and strictly proved with credible evidence by the claimant that the claimant has failed to plead his payment voucher from his employer or statement of account. Counsel referred the court to the case of Ede and Governor of Abia State. Counsel finally stated that where evidence adduced by plaintiff in proof of special damages is rejected by court, his claim comes to an end as the court is not entitled to embark on its own assessment of the special damages using its conceived parameters in place of evidence. Also, urged the court to dismiss the suit against the third defendant with cost. Final written address of the claimant dated 25th March 2020 was filed on the 8th of July 2020, wherein two issues were raised by counsel for determination as follows. Number one, whether or not any of the defendants have proffered defense to the claims of the claimant in this suit and the effect thereof. Number two, whether or not the termination of the claimant's appointment as the first and second defendant was lawful and the effect thereof. Let me just skip the arguments. Yes. On the 11th of November 2020, the first and second defendant filed a reply on points of law to submission of the claimant, even though they called no witness. Counsel, the first and second defendants submitted that the claim must succeed on the strength of his case and not on the weakness of the defense, and cited the following cases in support. Counsel contended that the claimant has failed to state his employees and place his contract of employment before the court or terms and conditions of his employment, as well as the way, manner, and by whom he was removed. According to counsel, the only document before the court in respect of the claimant's employment is exhibit FTT01, which is not party to. That by the decisions in Nigerian Telecommunication PLC and Mr. ID Akwa and Modu Aji and Chad Basin Authority, claimant has responsibility to place his terms and conditions of employment before the court and prove the manner they have been breached and by who. Counsel further submitted an employer has the power to hire and fire at any time without any reason. Counsel started the case of Samuel Iola and Nigerian Telecommunication Limited. According to counsel, there is nothing before the court to show that the appointment of the claimant was statutory. So submission of counsel that termination of appointment of the claimant is neither wrongful nor unlawful, as it's not in breach of the terms and conditions of the contract of employment. Counsel referred to the case of West African Examination Council and Felix Oshionobe or Oshionebo. Counsel submitted that a willing employee cannot be forced on an unwilling employee. An unwilling employee cannot be forced on an unwilling employer, as stated in West African Examination Council and Felix. Counsel urged the court to discountenance all submission of the claimant in his final written address and dismiss the suit with punitive cost. Third defendants applying points of law to the claimant's final written address was filed on the 8th of November 2020. Let me just skip the argument. So my opinion, I've read the pleadings of the parties and looked at the evidence adduced and studied the submission of the respective counsel. And on that note, I've chosen the third issue submitted by the third defendant to address the whole lot of issues submitted by the parties. The issue is thus, and I quote, whether or not the claimant has proved his case to be entitled to the reliefs sought in this case. Let me quickly stress that it was earlier noted that the first and second defendant, though filed a statement of defense, but did not call evidence to support their pleadings. The point must be underscored that the arguments and pleadings are fact as perceived by the parties relying on them, and there must be oral or documentary evidence to show that the facts pleaded are true. Consequently, pleadings without evidence to support them are worthless and will certainly be deemed abandoned. The case of Cameroon Airlines on Ututuzu. Therefore, the amendment made in the first and second defendants' pleadings, having not been supported by evidence, got no issue and are accordingly dismissed, abandoned. And as such, their counterclaim ought to fail and be dismissed, and I so order.
Okay.
Let me also address somewhat few preliminary issues raised by the claimants. Letter counsel for the claimant contained in their submission that the system and oath of the third defendant witness invalid because it does not contain the mandatory clause as prescribed by Section 13 of the Oath Act 2014, and that the decision in GTV and Abiodun on that issue must be followed by this court. It was further argued that the assessment of defense of the third defendant is also invalid as there is no indication or mark showing who actually among the listed counsel signed the document. I must say that the law does not require a deponent to use the exact words in the Oath Act. I believe anything in substantial compliance with the requirements of the Act will be enough in this era of technical justice at the expense of technicalities. In the case of Etienne and Inyong and Ojibara and Governor of Kwara State. In my view, that an affidavit which is said not to comply with the provision of Section 13 of the Oath Act is merely defective in form, not in substance. And any omission to include the words stated in that section will not, in absence of any fundamental defect as to substance, render the affidavit invalid, since the omission of the word will only affect the form in which the affidavit is presented. So saying Commissioner of Plan and Suji that the form stated for concluding an oath in Section 13 of the Oath Act is merely directory. It's neither compulsory or mandatory. The era of undue reliance on technicalities is long gone. With regards to the case of GTV and Abiodun Supra cited by learned counsel for the claimant, it must be borne in mind always that each case must be considered on its own particular fact or circumstances. No one case is identical with the other or another. They may be similar but never identical. So it is with the instance case. It is settled that a decision is only an authority for what it decides and nothing more. On the issue of whose signature on the third defendant's statement of defense, I will look at the process. There are 4 names, and the name of SM Onekutu is the first in the list. On top of it, there is a signature. There is also a seal of Simon Musa Onekutu on the process. Contend that the name of the counselor who signed the process must be ticked is, in my view, too trivial and misconceived. The case of Williams and Adol Stam International Nigeria Limited and Mena and EFCC, cited by learned counsel for the third defendant, are most relevant and on point. For the substantive matter, the claimant's grievance is that the termination of his appointment by the first and second defendant is null and void. We also asked for an order for payment of salaries and damages. Under relief, one of the claimant's reliefs, he alleged the termination of his appointment was done in breach of the terms of the tripartite agreement, Exhibit FTT01. The claimant in proof of wrongful termination is required by law to plead the terms and conditions of his employment and how they have been breached. In other words, he has to place before the court the terms of his employment, show the manner in which the terms have been breached, and who has breached them, and same as his contract of service forms the bedrock of his case. In the case of NRW Industrial Limited and Akim Bulukbe, Apex Court has held that an employee who seeks declaration that his employment was wrongfully terminated must prove 1, that he is an employee of the defendant. 2, the terms and conditions of his employment. 3, the way, manner, and by whom he can be removed. 4, the way and manner, the terms and conditions of his employment were breached by his employer. See the case of, Boy, Obu, and NMPC, Olorun Toba, Oju, and Abdurrahim. The claimant has relied heavily on exhibit FTTO 3 as his appointment letter. I've critically produced exhibit FTT 3 and found that the document is an introduction letter of the claimant to the third defendant. For clarity purposes, let me reproduce the content of exhibit FTTO 3 below. Court, African Community Bridge Foundation, August 30, 2013, Director of Development Finance Department, DFD, Central Bank of Nigeria, sir. Notification of our new substantive program director for Makodi EDC. This correspondence comes as a formal introduction of our new substantive program director, Professor F.M. Tehimba, PhD, FIAM, FCAI, FIPMA. We are notifying you of this replacement as an update. Professor Tehimba offers 20 years of effective leadership and continuous professional experience in both international development and entrepreneurship development. As can be gleaned from his CV attached, Professor Tehimba has what it takes to move Makodi EDC to new heights. He's also a native of Makodi, Benue State. Please update your records accordingly. The contact information for Professor Teo is .. All correspondence should be directed to him. If you have any questions or need further clarifications, please contact me at email on africancbf@org. Sincerely, Oge Onwansu, President. I find from the above that the content of Exhibit 3 cannot and is definitely not a contract of employment. It's rather a letter addressed to the Director Development Finance Department, introducing the claimant as a new program director. Claimant under cross-examination by the counsels of the first and second defendants stated, and I quote, I was appointed a program director of the third defendant. The CBN Entrepreneurship Development Center appointed me. One Oge Unwansu, who is an agent of the CBN, signed the letter of appointment. Equally, the claimant, while being cross-examined by the third defendant on 31st of October 2019, stated thus, I don't expressly have a letter of appointment from the second defendant, but I have one from the third defendant agent, that is Oge Unwansu. Even though the first and second defendant feel there no witness to support their pleadings on this assertion, which they deny in their defense, the third defendant during cross-examination maintained that the third defendant is not the employer of the claimant and has placed reliance on clause 5.3 of Exhibit 1. I believe that all the arguments and contentions about who is the employer of the claimant can only be resolved by the availability and production of the contract of employment of the claimant. While scrutinizing Exhibit FTTO3, I observed that there's nothing on its face showing that there is any right, liability, or obligation of any of the parties to this suit. I find that Exhibit 3 is unpersuasive for what it pretends to achieve. I suppose that it is intended to prove the existence of the contract of service, but it only appears to be deficient in itself to constitute a contract of employment, and therefore minded to find that it's not helpful to prove that the claimant is an employee of the defendant, or to prove the terms and conditions of his employment, the way and manner and by whom he can be removed, and the way and manner the terms and conditions of his employment were breached by his employer. The claimant admitted having a letter of employment from the third defendant, but the letter does not appear to be before the court. Taking that into account, how then can this court accept the assertion of the claimant in the face of copious denials by his supposed employer, and concerning the fact that relief 1 sought by the claimant to avoid his termination is a declaratory one? Furthermore, the claimant has also placed heavy reliance on Exhibit 1 as regulating his employment. Exhibit 1 is a tripartite agreement between the third defendant, the first defendant, and the government of Benin State. The claimant is not a party to it, but can only rely on it if he is shown to be a staff of any of the parties to the agreement. The roles and responsibilities of each party to Exhibit 1 have been clearly spelled out. And under clause 6.5, it is the duty of the first defendant as the implementing agency to oversee recruitment, remuneration, progression, and exit of staff of the EDC. Clause 2.5 of Exhibit 1 reads, and I quote, the implementing agency staff for the purpose of the implementation of the EDC shall not be regarded as a staff of the bank and shall not hold themselves out as source to members of the public, unquote. There is nothing in Exhibit 1 showing that it regulates the purported employment relationship between the claimant and the defendant. And in the absence of the letter of employment of the claimant showing that the claimant is a substantive staff of the defendant, then clause 6.11 of the Exhibit FTTO1 will not apply. And the court cannot discern if the termination of the appointment of the claimant was wrongful or not. I therefore cannot find any basis for the grant of relief 1. The relief 2, the claimant seeks an order for payment of his salary of 616,000 naira from April 2016 to date. This set of claim is for liquidated sums of money which falls under special damages and must be specifically pleaded and specially proved with credible and compelling evidence. They are the type that the law would not presume to flow or infer from the nature of the act or breach of duty complained of by the claimant. They are exceptional in their character and cannot specific items of loss which the claimant alleges as a result of the defendant's act of breach. Unlike general damages, there must be claims specifically and proved strictly, and the court is also entitled to make its own estimate of them. See the case of Enea and Pakara. Judicial decisions are replete that the claimant has to plead and establish how he arrived at the figures he is claiming as his salary. See a Supreme Court case of IHA, ABU, HMB, and Kanyip. However, the claimant in the instant case has not shown how he arrived at the figure of 616,000 naira as his salary. The claimant, as CW1 stated during cross-examination by counsel to the first and second defendant, that, and I quote, I was being paid salaries by the third defendant, unquote. But there's no bank statement or account, payment voucher, or payment slip to support this assertion. In the absence of any evidence backing up the claim, the court cannot grant special damages on guesswork or mere estimates. In the case of Aji, Botosho, and Construction Company Limited. Relief 3 is for 50 million naira as Naira Jamis for wrongful termination of appointment and non-payment of salary. Holding in the case of Afolabi and Ola is that general damages are only awarded where there is a breach. And having reliefs 1 and 2 fail, this relief is also bound to fail. The claimant further seeks for payment of 5 million naira as cost of this suit. There is also no evidence before this court in support of this claim. Apex Court has held in Mwanji and Coastal Services Limited that a claim for solicitor's fees is unusual and difficult to accept in our country, especially where there is no agreement between the parties and no justification for a grant of same. Claim for cost of litigation is accordingly refused. Although the first and second defendant adduced no evidence in support of their pleadings and chose to raise their case on that of the claimant, however, the claimant still bears the burden to establish his claims as he cannot rely on the weakness of the defense to prove his case. In the case of Okedare and Adebare, a party may, however, rely on the weakness of the defense to prove his case, while the case of defense supports his claims. But that's not the case here. See the case of Eze and Atashi, and Shitu and Fashowe. The court has said that in declaratory reliefs, the claimant has the duty to satisfy the court by evidence and not through admission in the pleadings of the defendant, that he is entitled to the declaration claimed. The necessity for this arises from the fact that the court has a discretion to grant or refuse the declaration. And success of the claimant in such an action depends entirely on the strength of his own case. In the instance case, I find the evidence adduced by the claimant as not only inadequate to grant the declaratory relief sought, but without weight also. See the case of Sif, Enus, Akingele, and Afribank Limited. Consequent upon the above, I am of the opinion that the claimant has not been able to prove his case on the balance of probability. His case lacks merit, it fails, and is accordingly dismissed.
The court please.
Stop, places. Lord, we appreciate the well-considered decision of the court in this matter too. We have picked so much from it. We are grateful, sir.
Thank you, Mr. Anazi.
Yes, my Lord.
Thank you so much, Mr. Mrs. Ede.
We are most grateful, my Lord, for the well-researched judgments.
Thank you.
However, we also make a passionate appeal to the court if the copy of the judgment can be sent to us via email.
Yes, I will ask my secretary to send it to you, and the soft copies and the hard copies will also be sent, God willing.
We are most grateful, my Lord.
Thank you. Mr. Onekutu.
My Lord, I join my learned friends to appreciate my Lord for this sound judgment.
Thank you.
We shall be asking my Lord to award
What?
cost in favor of the third defendant.
Against the Almighty CBN. Okay, in favor of Almighty CBN.
So the claimant has put the third defendant to a lot of expenses. I'm not even sure that the paltry amount we are asking for will compensate for all the trips that we made from.
But you are the ones printing the money now.
Yes, my Lord.
Mr. Anuku, you are the ones printing the money.
It's all right, my lord.
My lord, I thought that Mr. Onekuti should be happy that we have kept him busy.
Yeah. Yes. You can go and collect the remaining balance.
My lord, the fact of the matter is that the claimant in this matter has put us under enormous stress. There were occasions we came to Bakudi and the claimant wasn't even ready to go on with his case. And all the trips we made came with a lot of expenses. And with all the risks that is associated with traveling this time.
But the third defender has been taking care of that.
Very well, my lord.
So there should be no cause for alarm.
I'll stop places, and Onekuti should not scare us from suing CBA again. Because the more we sue, the more he will be employed.
So on this note, gentlemen, I thank you all. I thank you so much. And that will be all for today. I wish you a very good evening and happy New Year in advance.
Same to you, man.
Merry Christmas in advance, and Happy New Year, my lord.
Thank you.
And we wish you an enjoyable holiday.
Thank you.
Thank you, sir.
So until we see next year.
By God's grace.
God bless us.
Yes. So you have a very good. You have a very good weekend.
Thank you, sir.
Then, bye-bye.
Bye.